This is the first video from a series where we will try to understand what really happened in the case of Quick Road Transport. Following a DVSA investigation, it has been discovered that all but one of the company's drivers were employed through their own limited company. This ended with the operator's license of Quick Road Transport being revoked. The Goods Vehicles Licensing of Operators Act 1995 legislates the operator's license requirement. For the purposes of this act, the driver of a vehicle, if it belongs to him or is in his possession under an agreement for hire, hire purchase or loan, and in any other case, the person whose servant or agent the driver is, shall be deemed to be the person using the vehicle, and references to using a vehicle shall be construed accordingly. The Traffic Commissioner's interpretation is this. In the case of a LTD driver, the driver is the servant of their own limited company. It is their limited company that pays them and gives them their directions. That may seem artificial in the case of a limited company whose only employee is the director who is the driver, but that is the law. Now let's leave Fantasyland and come back to the real world. Despite the head-spinning phrasing of the Act, it is simple to understand that the one that needs to have an operator's license is the one engaged in a carriage of goods contract. So let's do what he didn't, the investigation to determine who that one was. Quick Road Transport had contracts with their clients where he would invoice the carriage of goods from A to B at specific dates and times, and sometimes even following a specific route. The limited drivers, same as the agencies, would charge Quick Road Transport based on labour over time, what work and for how long. None of them had their revenue affected by the performance of the shipment unless they were the ones causing it. A road closure, for example, for any haulier out there is always a loss, additional cost with fuel, labour, etc. For both the limited driver and the agency, such an event will increase their revenues with additional charge time. It could have been as simple as that to avoid the catastrophe he made. To summarise it, we have two entities, the limited driver and the agency, both behaving the same way, both providing drivers to their client, both charging the same services, yet the Traffic Commissioner managed through some miracle to determine that one is an illegal operator while the other one is not. How did this happen, you wonder? I bet at this moment they are asking themselves the same question. Well, when you poke into things that you don't understand, like IR35, you find yourself in the false belief that the control the operator has over the limited driver is different. Well, it isn't. The operational control is the same in both cases. All drivers, including the operator's employees, are under the same level of direction, supervision, and control. What the operator doesn't have is the administrative control over the agency or the limited company hiring the driver. Both decide what and if they agree to an engagement and under what conditions, something that the employed drivers cannot do. I know I said earlier direction, supervision, and control. So let's give the Traffic Commissioners a free lesson about IR35. HMRC cannot possibly know and understand all the insights of every single industry. Unfortunately, they have issued a guidance, and I must emphasize that is a guidance and not law, placing the limited drivers in a position similar to one of a transport company. Again, unfortunate but to some degree understandable. The question is, how can you, Traffic Commissioners, make such a confusion? How can you make such a mistake? Before enforcing IR35, it is important to fully understand the law and not simply rely on selective parts of guidance. Enforcement must be based on the actual legislation, not just on what might seem convenient or favourable at the time. The direction, supervision and control, for the purpose of the assessment, is being done between the end client and the first company employing the driver, not the driver. ESM 10017 Basic Principles Off-Payroll Working, and the contractual chain says that the lowest person in the chain for the purposes of the off-payroll working rules is not the worker, it is the worker's intermediary. As explained earlier, the client has these over the worker and not over the contractor companies. For the IR35 purpose, a genuine engagement such as this will pass this test. In the next video, we will go over some other interesting failures of the Traffic Commissioner in the decision-making of this case.